Good morning, everybody, and a very warm welcome to this morning's seminar, which focuses on the 10 things you need to get right when employing people. So before I start, I'd like to introduce myself. I'm Victoria Templeton and one of the HR Knowledge Managers at HR Solutions. Having nearly 25 years HR experience gained in travel, financial services, insurance and outsourcing, I joined HR Solutions in 2019. I joined as a member of the HR helpline, offering telephone and email advice to our client base. I then took up the role of HR Knowledge Manager just at the start of the first lockdown, supporting our client base through the pandemic from an employment law perspective, which has been through delivering COVID-themed webinars, template policies, letters and guidance articles. COVID continues to be a challenging time for us all. However, regardless of what is going on externally, there will always be the same fundamentals when it comes to employing people. And so this seminar is going to look at my top 10. So our first area to look at is contracts of employment. And in July 2017, the government commissioned Matthew Taylor to carry out an independent review of modern working practices. This review was called the Good Work Plan, and the principal aim of the review was that all work in the UK economy should be fair and decent with realistic scope for development and fulfilment. When the review was concluded, the government accepted many of its recommendations, and we saw several of these being adopted into law in April last year. So when it comes to recruitment and contracts of employment, it now means that all workers have a right to have a written statement of employment. So whereas before this right was only for employees, the Good Work Plan extended this to cover workers. And a person is deemed to be a worker when they work under a contract whereby they undertake to do or perform personally any work or services for another party. They are free to accept or reject any offers of work made to them by other organisations. There is a legal requirement for an employee or worker to be given a written statement from day one of employment, and previously to this, an employer had 1 month from the start date to provide this. And it also brought in further requirements in terms of what information must be included in a written statement. So now it is a legal requirement for employees to include a breakdown of the hours and days of the week, whether the hours may be varied, and if so, how, plus any entitlements to any paid leave must be stipulated, as well as any other benefits not covered elsewhere. And finally, details of any probation period and training to be provided. We also saw changes being made to how holiday pay is calculated for those who work variable hours. So rather than using a reference period, which looks back over the previous 12 weeks to calculate a week's pay, the reference period now looks at the previous 52 weeks. And this should be made clear in the written statement. When it comes to paying employees, including those who are casual or on temporary contracts, as well as agency workers, they have a legal right to a minimum level of pay. What that level of pay will be will depend upon their age, and these rates are updated in April of each year. As you'll see here in the table, the rates of pay will be from April 2021, and that there is both a national minimum wage and a national living wage. Essentially, it's a different title based on the age of the employee. Both are still statutory requirements. And another requirement around paying people is to pay statutory payments, subject to eligibility, of course. So this will be payments in respect of statutory sick pay, holiday, maternity, adoption, paternity and parental leave pay, notice pay where you're paying in lieu of notice, as well as redundancy payments. And on a side note, in regards to SSP, organisations can currently claim 2 weeks of SSP back from the government when SSP has had to be paid in connection with COVID-19. Another legal requirement is that your employees are entitled to itemised pay statements at or before the time any wages are to be paid. Now this is crucial as it enables the employee to have sufficient information about their pay to understand how their net pay is being calculated. The information that must be contained within a pay statement includes the gross and net pay, amounts of variable and relevant fixed deductions, the amount and method of payment where different parts of the net amount are paid in different ways, the total number of hours worked where the amount of wages varies by reference to time worked, and details of any fixed deductions. And finally, in order to comply with these statutory requirements, then it is important that you have a robust system in place to record the hours worked, the salaries paid, and to evidence that both the national minimum wage has been paid and the working time regulations have been complied with. And we're now going to look at item number 3, which is the working time regulations. So the working time regulations are fundamental to the employment contract, as they set out the rules on how you manage working hours, rest breaks, night workers, annual leave, and how these rules may alter depends on the employee's age and job role. So it can be complex, as there are many variables to think about, which I will shortly cover. But before I do, I just wanted to highlight some different elements of the regulations for you. So first of all, working time is restricted. There is a maximum weekly working time which must not be exceeded, and depending on the age will determine what that limit is. Working time does include job-related training, travel time as part of the job, and following a case ruling last year, it now includes travel and wait time of up to 60 minutes between client visits. And it also includes working lunches and overtime. For those employees who may have multiple jobs, then where there is no opt-out agreement signed, each employer is responsible for ensuring that the 48 hours are not exceeded. We would recommend that employers include a provision in their contracts of employment requiring employees to obtain specific consent before taking on any additional outside work, because that will help businesses know where there may be issues with the maximum working week. And finally, we should not forget that the main purpose of the working time regulations is to provide rest breaks for employees. Within the regulations, there are rules around statutory paid holiday, and all employees and workers are entitled to 5.6 weeks paid annual leave each year. And those who are part-time will have entitlement that is prorated based on the number of working hours they work. But it is for an employer to define their own holiday year and policy for managing the working time regulations annual leave. So I mentioned working time is a complex area. There are many variables such as age, role, industry, or what is in the contract of employment. And this table highlights just some of the different areas that I've just mentioned. So it is highlighting the differences between the two age groups when it comes to maximum weekly hours that can be worked. So for those over the age of 18, and the working hours must not exceed an average of 48 hours in each 7-day period. And to get that average, you look at the hours worked over a 17-week reference period. Now, this part of the regulation does allow for an employee to opt out, and so where they do, there must be a written agreement in place that is kept on file. For those above school leaving age, but under 18 years of age, then their week is limited to 40 hours. The hours cannot be averaged out, so there is no reference period, and nor can they opt out of this part of the working time regulations. Daily rest breaks also differs depending on age, and as an employer you can say when the employee takes rest breaks, but it has to be taken in one go in the middle of the day, so not at the start or the end of the day. It must be so that they're allowed to spend it away from the work desk or workstation, and under the working time regulations they are unpaid. Of course, if the contract of employment says otherwise, then you must follow what's in your contracts. And then there are rest periods, which are different to breaks. So this is how long, as a rest, as a minimum, you must have away from the workplace between shifts or working days. So here you can see how this differs depending on the two age groups. And then night working, and this is probably perhaps the most complex, as there are exceptions that can apply, and it will depend on the industry that you operate in and the role that the person does. But this is, I guess, hopefully giving you a good indication of the working time regulations. And we're now going to move on to number 4, which is all about recruiting from outside of the UK. Now, recruitment has seen a significant change since the UK left the European Union, and we have seen the introduction of a new points-based immigration system. The implications of leaving the EU has meant that the end of free movement of people has occurred, hence why recruitment has had to change. So from the 1st of January of this year, EU nationals wishing to live and work in the UK for the first time are required to apply to work in the UK through a new points-based immigration system. The visa schemes that were previously in place for recruiting non-EU nationals have been consolidated into this new points-based system, which means both EU and non-EU nationals are going to be treated equally in respect of coming to work in the UK. And under the new points-based system, the UK employer is required to hold a sponsor licence in order to recruit from outside of the UK. Now, if you were employing EU nationals as at the 31st of December last year, and they want to continue working and living in the UK this year, then they must apply to what's called the EU settlement scheme. And by doing so, they will be granted either pre-settled or settled status. Now, they have until the 30th of June 2021 in which to apply. And it's really important to note that it's something that they must decide, and actually they cannot be required to do this by their employer. So to keep it simple, we can break it down into two groups: those who are already in the UK as at the end of last year and who need to go through the EU settlement scheme, and those who are new to entering the UK from this year onwards and who need a visa. Now, the visas available under the new points-based system include a skilled worker visa, where they will need to score 70 points going through having a job offered by an approved sponsor. The job must be at the required skill level, and that they must be able to speak English at the required level. And then there is also the intra-company transfer. So if you already have an employee working overseas, but you'd like to transfer them to the work into your UK offices, then the employee will be able to apply for this type of visa. They must be an employee of the company, have 12 months experience working for a business overseas linked by ownership to the UK business, and undertake a role at the required skill level and be paid at least £41,500 or the going rate for that job, whichever is the highest. Now, there are some exceptions to this visa, because where the salary is significantly higher, it will mean that the 12 months experience won't be required. But in effect, there is an avenue for overseas employees to come and work in your UK offices. Now, it is likely that these two types of visas will be the main visa routes for working in the UK under this new system. Although there are other types of visas that do exist, such as the Global Talent Visa, the International Students and Graduates Visa, and the Startup and Innovative Visa. And this leads me nicely on to item number 5, and it's all to do with right to work checks. So you will already know that there is a legal duty on employers to prevent illegal working, and this is achieved through having correct right to work checks and processes in place, so that all new hires confirm they are entitled to work in the UK. Now, checks can be manual or online, and if it is a manual check, then a clear copy of the original documentation should be taken and retained by the employer with a record of the date that check was made. For an online check, a clear copy of the response provided by the online right to work check must be retained as well by the employer, again with a record of the date the check was made. Now, in light of the pandemic, the Home Office made temporary emergency changes to the right to work checks, including that these can now be carried out via video calls. Job applicants and existing workers can send scanned documents or a photo of documents for checks using email or a mobile app rather than sending originals. Employers should use the employer check-in service if a prospective or existing employee cannot provide any of the accepted documents. And right to work checks must be carried out on all employees, new applicants, and before they commence work. Now, as part of the transition to using this new points-based immigration system, there is actually a 6-month grace period in which employers will be able to continue to accept passports and national identity cards as part of their usual right to work checks. This will be in place until the 30th of June this year, after which EU nationals who do not have settled or pre-settled status will require a visa to work in the UK in the same way as non-EU nationals. But there is an oddity about this, because on the one hand, the new points-based immigration system came into effect on the 1st of January, yet employers can continue to use evidence as before for verifying the right to work. And now we're going to move on to number 6, which is all about job descriptions and person specifications. and sometimes there is confusion between the two. So a job description, as the name indicates, describes the work which the job holder must carry out. It outlines the tasks, duties and responsibilities, whereas the person specification describes the characteristics, skills, abilities, experience, etc., which the job holder must have in order to carry out that job. Now, job descriptions are vital not just for setting expectations, but it is a vital tool in supporting the company's appraisal system and ultimately managing performance. In terms of the person specification, then this is probably the most valuable tool in the whole of the recruitment and selection process, as it will form the basis of any advertisement which are drawn up. It will provide those doing the shortlisting with the criteria to screen applications, and it will enable interviewers to structure their interviews and decide who to select and who to reject. Of course, it also underpins any processes used in how you manage an employee's performance once they're employed. Where person specifications aren't used, employers risk discrimination claims because the selection of candidates may depend more on the likes and dislikes of an individual interviewer. There is of course no legal requirement to have either of these documents. However, the benefits are massive to an organisation, and we would advise that they are in place. And moving on to number 7, we're going to look at essential policies. So when employing people, there needs to be in place well-written and communicated policies and procedures. Employees, workers and job applicants can all bring claims to an employment tribunal. And so having clearly laid out and well communicated policies can help in avoiding and defending claims. So not only can they help with this, but they can also provide guidance to your line managers. They can enable you to implement your HR strategy. They ensure that your managers are acting consistently with all employees, which comes back to that first benefit about avoiding tribunal claims. And finally, they can help in the development of a fair and inclusive culture, as they bring transparency to the business in terms of how you manage your people. And therefore, it shows your workforce how they are to be treated and that they are going to be treated in the same way. And in terms of the key 10 policies that are going to be essential even for small employers, then my top 10 would include the absence notification and sick pay policy, bullying and harassment, family friendly, and that would include your maternity, adoption, paternity and parental and shared parental leave. Now they can either be individual policies or you can amalgamate them into one family friendly policy. You then have a need for a disciplinary, equal opportunities and grievance policy, and then a health and safety, performance standards, recruitment and selection and whistleblowing. These are all really essential policies to have. And once in place, these policies need to be reviewed and updated to reflect changes in legislation, case law and your organisation itself. An annual update can also serve to keep the policies fresh in your employees' minds. Now, if your HR policies are non-contractual, it means that it will be relatively easy to issue notice of any proposed changes and invite comments or suggestions prior to implementation. So I would recommend, if possible, having non-contractual policies. And if we now move on to number 8, which is all about health and safety, then we have the Health and Safety at Work Act of 1974. And an employee's duty is to protect the health and safety and welfare of their employees and other people who might be affected by their business. And this includes employees who work from home. However, there are also several key pieces of health and safety legislation that is relevant. For example, we have the Management of Health and Safety at Work regulations, we have the Workplace Health and Safety and Welfare regulations, the Health and Safety First Aid regulations, the Health and Safety Information for Employees, and the Corporate Manslaughter and Corporate Homicide Act of 2007, just as examples. So from a practical perspective, in being compliant with all of the different pieces of legislation, I would suggest having in place 5 key steps to effective health and safety management. So first of all, having a set of policies. So if you employ 5 or more people, then there must be a written health and safety policy, although we would advise that this is in place even for those employing less than 5. You want it to cover your general statement on health and safety and describe the organisation and detail the arrangements you have in place for carrying out the policy. The policy must be brought to the attention of all employees and revised whenever appropriate, bringing any changes made to the attention of your workforce. And secondly, it's about organising your staff. So there needs to be somebody responsible for the day-to-day implementation of the policy, but then have somebody more senior who has overall responsibility and accountability. And then it's about ensuring you have other personnel lined up who can become your first aiders and fire marshals. All staff, however, must know their own health and safety responsibilities and where those responsibilities stop, who has authority over whom and in what circumstances. And so it's a requirement under the Health and Safety at Work Act to provide training and to refresh that training periodically. And then if we then move on to think about planning and setting standards, that's about ensuring you identify the health and safety standards appropriate to your workplace. So an office environment is very different to a factory, so it's about having those standards that are appropriate for your business and therefore the risks that are associated with it. And it's then about ensuring you can put plans in place to enforce those standards and ensuring you maintain your duty to protect the health and safety and welfare of your employees. And with any policy, it's important to measure its performance. So you'll want to have measures in place to ensure that it is clear and easily understood, that it is working, and that it is supporting the business in maintaining a safe workplace. This then becomes part of your audit and review, which is going to be essential. And finally, in regards to health and safety, I just wanted to finish this section just by picking up on 3 particular topics: risk assessments, COVID-19 and mental health first aiders. So we know under the Health and Safety at Work Act that employers have a duty to protect the health and safety and welfare of their employees. And it is for this reason that we must have in place thorough risk assessments. So risk assessments involve ensuring that workers and others are protected from anything that may cause harm, controlling any risks to injury or health and assessing those risks. So risk assessments are mandatory for all employers, and so there's that legal duty to complete. Written records of risk assessments must be kept where 5 or more people are employed, although we would advise that written records of the risk assessment are kept regardless of how many people are employed. Now, in regards to COVID-19, we have seen the spotlight on risk assessments. The government, in consultation with professional bodies such as the HSC, as well as trade unions, have developed a set of documents for employers to help them ensure their own workplace is what we call COVID secure. Now, whilst we cannot entirely remove the risk of COVID, following these COVID secure measures, having a dedicated COVID risk assessment in place that is monitored and reviewed regularly will help to protect everyone and mitigate against risk. And finally, we know from the World Health Organization that depression is the biggest disability. We're seeing more and more mental health occurring as a result of COVID and lockdowns. We also know from the Health and Safety Executive in their report for 2019-20 that 828,000 workers suffered from work-related stress, depression, or anxiety. That equated to 17.9 million working days that were lost due to those same reasons. And 51% of all work-related ill health was due to depression or anxiety. So we would encourage having mental health first aiders within the business as a support mechanism for your staff. These would be in addition to your first aiders. Mental health first aiders can act as a go-to for those who are struggling. They can look out for key signs and symptoms and know to call help when needed. And now we move on to point number 9, and this is to do with pensions. And all employers are legally required to offer a workplace pension scheme. And since 2012, on a gradual rolled out basis, organisations have been required to auto-enrol their employees into a pension scheme and make contributions where the employee is eligible. Now, there are several types of pension schemes, so I just want to, at a high level, flag what these are. So first of all, there are the occupational pension schemes, And these are paid in addition to the state pension and offer tax relief on contributions, which are generally made by the employer as well as the employee. In addition, other benefits such as life assurance or pension for dependents in the event of a member's death are often offered as part of these schemes. They are managed by trustees or scheme managers, and if an employee leaves the company, they are generally unable to transfer between employers, and contributions therefore cease upon leaving the employment. If the schemes can be categorised into two, so there's defined benefits, also known as final salary, and the pension is based on the number of years service in the scheme, and earnings may often be an average of the latter, example, an average of the highest of the last 3 years. There are minimum funding requirements and the employer is required to top up the fund as necessary. Then there's defined contribution, also known as money purchase schemes, and these are based on the amount of money the employee and the employer have contributed to the scheme over the years, how that has all been invested and the return on that investment. Part or all of the fund may then be used to buy an annuity, which provides for a regular income for the rest of the member's life. Then there's group personal pensions, and an employer can choose to provide access to a personal pension scheme and can also choose to make contributions to that scheme. The member may continue paying into the scheme after leaving the employment, and the money pot at the retirement converts into an income for that employee. And finally, there are personal pensions. These can be purchased from banks, building societies or insurance companies. An individual contract will be in place between the pension provider and the member of staff. Members may normally only claim pension payments from the age of 55, and there may be certain circumstances that will allow employees to take their pension before the age of 55. But the pension scheme provider will outline what a particular scheme allows, and the upper pension age at which all pensions must start to be taken is 75. And finally, on number 10, and this is about employee benefits. So retaining your employees is going to be key for rebuilding your business following the pandemic. You're going to need stability and have a workforce that's experienced and knowledgeable, because all of this will help move the business forward. As a result of COVID, we do expect benefits such as income protection, health insurance, life insurance, increased holiday to be sought after from employees. And this came through some research carried out last year, rather than things like company cars, private medicals, health screening. And I think it's simply because the psychological impact of COVID-19 has been significant, and so perhaps the last 12 months has reminded people of the importance and need to safeguard their future and finances, not just for themselves, but for their family. Building a benefit offering that includes financial and non-financial benefits is likely to have a high impact on morale, help retain your staff as well as attract candidates when recruiting, and impact positively on employee engagement. So some examples of employee benefits will include health screening, private dental care, company cars, or buying and selling holidays, free refreshments at work, gym memberships. So there's many to think about, but it doesn't all have to be financial, it can be non-financial as well. And consider reviewing and updating your benefits offering to retain your staff, as I've explained. Having an effective and desired reward package will be key. And you could also consider having a flexible benefits system to tailor compensation packages to an individual, which would enhance employee engagement even further. And so this brings me to the end of my top 10 things that you need to get right when employing people. I really hope that you found this information helpful. And before I close, I would like to just share with you how you can access our free risk audits. So we have several in place that covers Brexit, GDPR, COVID-19, HR risk and health and safety compliance. They take no more than 15 minutes of your time, and they provide you with insights into how you can minimise any risks that may have been identified. And you can access these by using the link shown on the screen. We would also like to offer a free 30-minute consultation with one of our HR experts on our HR helpline, should you have a burning issue or would like to discuss a case you may have, and you can do so in confidence. And finally, If you would like to stay in the loop and be amongst the first to be invited to any of our free HR and health and safety webinars, as well as receive our latest newsletter, then please do sign up via the link again that's showing on this screen. And of course, if you do have any further questions, then please contact us on the information showing on the screen and we'll be more than happy to help. And I'd like to close by thanking you all for joining us today. I hope that you have found it useful and we look forward to welcoming you on our HR and health and safety webinars in the future. Thank you.